Hello everybody, my name is Anthony Santangelo, and I'm a patent attorney here in the Philadelphia area. Welcome to my presentation on the provisional patent. A complete provisional application filed under 1.53c comprises a cover sheet, a specification, drawings when necessary, the prescribed filing fee, and the application size fee. A provisional application for patent shall be made or authorized to be made by the inventor. The cover sheet is required. This may be an application data sheet or a cover letter identifying the application as a provisional application. The office will treat an application as having been filed under paragraph B, a non-provisional application, unless the application is clearly identified as provisional. This is an example the application data sheet. An application data sheet is a sheet or sheets that may be voluntarily submitted in either provisional or non-provisional applications, which contains bibliographic data arranged in a format specified by the office. An application data sheet must be titled Application Data Sheet and must contain all of the section headings listed in paragraph B, with any appropriate data for each section heading. If an application data sheet is provided, the application data sheet is part of the provisional or non-provisional application for which it has been submitted. Applicant information. Information that's required includes the name, residence, mailing address, and citizenship of each applicant. The name of each applicant must include the family name and at least one given name without abbreviation, together with any other given name or initial. If the applicant is not an inventor, this information must also include the applicant's authority to apply for the patent on behalf of the inventor. Correspondence information. This information includes the correspondence address, which may be indicated by reference to a customer number to which correspondence is to be directed. Application information. This information includes the title of the invention, a suggested classification by class and subclass, the technology center to which the subject matter of the invention is assigned, the total number of drawing sheets, a suggested drawing figure for publication, any docket number assigned to the application, the type of application, for example, utility, plant, design, reissue, or provisional, whether the application discloses any significant part of the subject matter of an application under a secrecy order, and for plant applications, the Latin name of the genus and species of the plant claimed, as well as the variety denomination. The suggested classification and technology center information should be supplied for provisional applications whether or not claims are present. If claims are not present in a provisional application, the suggested classification and technology center should be based upon the disclosure. Representative information. This information includes the registration number of each practitioner having a power of attorney in the application, preferably by reference to a customer number. Providing this information in the application data sheet does not constitute a power of attorney in the application. Domestic priority information. This information includes the application number, the filing date, the status, including patent number if available, and relationship of each application for which benefit is claimed under 35 U.S.C. 119E, 120, 121, or 365C. Providing this information in the application datasheet constitutes the specific reference required by 35 U.S.C. 119E or 120 and need not otherwise be made part of the specification. Foreign priority information. This information includes the application number, country, and filing date of each foreign application for which priority is claimed, as well as any foreign application having a filing date before that of the application for which priority is claimed. Providing this information in the application datasheet constitutes the claim for priority as required by 35 U.S.C. 119b. Assignee information. This information includes the name, either person or juristic entity, and address of the assignee of the original right, title, and interest in an application. Providing this information in the application datasheet does not substitute for compliance with any requirement of Part 3 of this chapter to have an assignment recorded by the office. 35 U.S.C. 112 Specification. The specification shall contain a written description of the invention and of the manner and process of making and using it in such full, clear, concise, and exact terms as to enable any person skilled in the art to which it pertains, or with which it is most nearly connected, to make and use the same, and shall set forth the best mode contemplated by the inventor of carrying out his invention. Arrangement and contents of the specification. The following order of arrangement is preferable in framing the specification. First, include the title of the invention. Next, cross-references to related. Next, statements regarding federally sponsored research or development. Next, the names of the parties to a joint research agreement. Reference to a sequence listing, a table or computer program listing appendix submitted on compact disc, and an incorporation by reference of the material on the compact disc. For computer listing, file reference to a sequence listing, a table, or a computer program listing appendix submitted on compact disc, and an incorporation by reference of the material on compact disc. For computer listings filed on or prior to March 1st, 2001, reference to a microfiche appendix. On or prior to March 1st, 2001, reference to a microfiche appendix. Background of the invention is next. The field of the invention is next, followed by the description of the related art. Include a brief summary of the invention next, and a brief description of the views of the drawing. Then follow it with the detailed description of the invention, the abstract of the disclosure, the sequence listing, and drawings when required. The applicant for a patent is required to furnish a drawing of his or her invention where necessary for the understanding of the subject matter sought to be patented. Drawings may include illustrations which facilitate an understanding of the invention, for example, flow sheets in case of processes and diagrammatic views. Whenever the nature of the subject matter sought to be patented admits of illustration by a drawing, without its being necessary for the understanding of the subject matter, and the applicant has not furnished such a drawing, the examiner will require its submission within a time period of not less than 2 months from the date of the sending of a notice thereof. Drawings submitted after the filing date of the application may not be used to overcome any insufficiency of the specification due to lack of an enabling disclosure or otherwise inadequate disclosure therein, or to supplement the original disclosure thereof for the purpose of interpretation of the scope of any claim. Fees. The National Application Filing, Search, and Examination fee for each provisional application for a micro entity is $65, for a small entity is $130, and any other than a small or micro entity is $260. The application must be accompanied by the fee required. The fee may be submitted after the specification and any required drawing are submitted within such period and under such conditions, including the payment of a surcharge, as may be prescribed by the director. Upon failure to submit the fee within such prescribed period, the application shall be regarded as abandoned unless it is shown to the satisfaction of the director that the delay in submitting the fee was unavoidable or unintentional. Filing date. A provisional application will be given a filing date in accordance with 37 CFR 1.53C as of the date of the written description, and any necessary drawings are filed in the office. Items not needed. The oath of the applicant is not needed. The 35 U.S.C. 131 examination of applicant is not needed. (35 U.S.C. 135 interferences are not needed). No claim is required in a provisional application. No oath or declaration is required. Provisional applications will not be examined for patentability, placed in interference, or made the subject of a statutory invention registration. (35 U.S.C. 157 statutory invention registration not needed). 37 CFR 1.54 parts of the application to be filed together. It is desirable that all parts of the complete application be deposited in the office together. Otherwise, a letter must accompany each part, accurately and clearly connecting it with the other parts of the application. Postcard. If a self-addressed postcard is submitted with a patent application, that postcard will be provided with both the receipt date and application number prior to returning it to the addressee. The application number identified on such a postcard receipt is merely the preliminary assignment of an application number to the application and should not be relied upon as necessarily representing the application number assigned to such application. The identifying date on the postcard should include the applicant's name, title, number of pages of specification, claims, sheets of drawing, whether an oath or declaration is included, a list of any additional forms, amount and manner of paying the fee. Filing of correspondence by express mail. Any correspondence received by the U.S. Patent and Trademark Office that was delivered by express mail post office to the addressee service of the United States Postal Service will be considered filed with the USPTO on the date of the deposit with the U.S. Postal Service. Converting non-provisional to provisional. An application for patent filed under B of this section may be converted to a provisional application and be accorded the original filing date of the application filed under paragraph B. A provisional application filed under paragraph C of this section may be converted to a non-provisional. A provisional application is not entitled to the right of priority or to the benefit of an earlier filing date of any other application. No claim for priority may be made in a design application based on a provisional application. No request for a statutory invention registration may be filed in a provisional application. The requirements of sections 1.821 through 1.825 regarding application disclosures containing nucleotide and/or amino acid sequences are not mandatory for provisional applications. A provisional application is a regular national filing that starts the Paris Convention priority year. Foreign filings must be made within 12 months of the filing date of the provisional application if applicant wishes to rely on the filing date of the provisional application in the foreign filed application. Thank you very much for attending this presentation on the provisional patent application, and visit fastpatentfiling.com for more information on how to file your patent.